seated. Ms.
Good
Meltzer,
morning, Your
seated.
Honor. Nice to see you as well. Good morning, Your Honor. Evelyn Meltzer of Troutman, Pepper, Hamilton Sanders on behalf of the debtors. We want to thank Your Honor for making time for this hearing today and specifically for allowing us to push the start back by an hour. I think, Your Honor, you will hear that we have used the time very well. I am pleased to report that I believe that we are fully resolved on both the store closing motion and the consignment motion, and that we are also resolved on the DIP motion other than the certain landlords who have objected to that motion. Okay. Before turning to the agenda, I did want to address a few housekeeping items. We had brought to the court today black lines of the revised DIP order, but then realized a change or two got made as we were on the way to court. So I'm going to tell people who to email if they want a copy of that, and we will be putting that up on the Zoom screen as well. And we also have black lines of the store closing motion and the consignment motion. If anybody would like copies of those black lines, please email Cynthia Vernon, which is CYNTHIA.Vernon, VERNON @troutman.com. And Your Honor, our plan is, assuming Your Honor enters those orders today, we will obviously file them under certification of counsel after the hearing. Additionally, Your Honor, I did want to flag an issue for you that we realized after the bar date order was entered yesterday. Under our local rule, the deadline for the debtors to file their schedules and SOFAs was this Friday. Our professionals worked extremely hard and actually filed the schedules and SOFAs this past Friday, May 26th. And then when the order got entered for the bar date order, we realized that it said that our claims agent in KCC would serve out our bar date packages within 5 days of our schedules, because we had assumed we were going to file them this Friday. And so we will be filing under certification of counsel a very simple order that simply says that the deadline for KCC to serve out the bar date package will be Monday rather than 5 days from last Friday. Technically 5 days would fall on Sunday, but obviously KCC can't serve it out on a Sunday, so we're bumping it to Monday. So I just wanted to make Your Honor aware of that issue, and so that you know a certification of counsel will be coming to address that.
Thank you.
And with that, Your Honor, I saw that certain orders that we had filed under certification of counsel had started to hit the docket. I don't believe that all of them have, however, so with that, I will turn it over to my co-counsel to start to address what has not yet been entered, and I believe what has been entered is customer program, insurance, and the OCP order.
Well, I think the only one that we haven't entered is the workforce obligations order. I think we've got everything else, or
it may not have hit the docket yet then. When you say the wage motion.
The
okay.
Wage motion, yeah.
Okay, perfect. So I will turn it over to Mr. Murphy to address that. Thank you.
Okay.
Good morning, Your Honor. Thank you again, along with Ms. Meltzer, for accommodating our schedule. I think it's fair to say that all parties, the committee, particularly its involvement, their most recent involvement has been productive, I think, in trying to close out some issues. And I'm going to let the committee speak directly to the court, Your Honor, rather than because they took the lead last evening with the DIP lenders regarding changes that affect the principal three motions, Your Honor, which would be the store closing motion, the consignment motion, and the DIP order. We had hoped, as Ms. Meltzer say, I think we have agreed upon orders on the store closing and the consignment motion. The DIP order is a work in process that we can walk through the hearing. But I think it's fair that Your Honor hear from the committee regarding what they've done and what they've accomplished and their recommendations going forward with respect to the three orders.
Yes, I'd like to hear from them. Thank you.
Good morning, Your Honor.
Good morning, Mr. Ward. Good to see you.
For the record, Matthew Ward from Womble Bond Dickinson on behalf of the Creditors Committee. I'm joined by my co-counsel from the Porzio law firm, Warren Martin and Christopher Mazza. I believe you have admitted Mr. Martin pro hoc. We filed a pro hoc for Christopher Mazza this morning. And the arrangement that we have, Your Honor, is a co-counsel capacity. So we have split the roles where we looked at the consignment and the store closing motion, and Mr. Martin handled the DIP, and we'll be speaking about that shortly. With respect to the store closing and the consignment, we did not have changes to the proposed form of order, but would like to put on the record a couple clarifying observations, which we understand are agreeable to the consignment party and the other parties in interest. The first is, with respect to the consignment order, paragraph 5 talks about a cure amount that will be paid out by the debtors in connection with the assumption of that agreement, and our understanding is that payment has already been made, and to the extent that payment has already been made, there's not a further payment contemplated as part of the cure. It's already been satisfied. The consignment agreement that is being assumed talks about a right of first refusal with respect to the consignment party to serve as the stalking horse bidder to the extent that there are GOB sales going forward. The issue there is we just wanted to clarify the wording that it is not necessarily they have a right of first refusal to serve as the stalking horse bidder for the GOB. It's if we get a stalking horse bid for the GOB, they will have the opportunity to review it and serve as a stalking horse bidder on those terms or better terms. If, however, say under a fiduciary out, the debtors view one bid as a lower bid or a better bid than the stalking horse offer presented by the consignment party, the debtors have the option to go with that better bid. They don't have to select this consignment party as the stalking horse bid, just have to be presented with the opportunity to match or serve it. And my understanding is they are agreeable to that as well. They may have some clarifying remarks too. And then the third point was the consignment agreement contemplates in Section 6C, under certain circumstances, that the debtor would have an obligation to buy out unsold inventory that is on the premises, and the deadlines for the debtor to have done that have already passed. And so we wanted to clarify on the record that there are no further or future obligations by the debtor with respect to those buyouts. And again, my understanding is the consignment party agrees with all of those. I can either turn it over to them if they have comments, and then subsequently moving on to the DIP motion, Mr. Martin could talk about the DIP motion in the committee's resolution with respect to that motion as well.
Great. Thank you, Mr. Wood.
Thanks, John.
Good morning, Mr. Glardy.
Good morning,
Good to
Your
see you.
Honor. Good to see you, and good to be in front of you for the first time on the other side of the bench.
Well, welcome.
Congratulations.
Thank you.
With respect to Mr. Ward, yes, the cure has been paid. Whether it was a cure or not, it wasn't in default as of the date we filed, so we confirm that. With respect to the right of first refusal, I'm just going to say I think it's simpler, probably the same. First, it in no way restricts the debtor's fiduciary duty to get the highest or best stalking horse bid. So that's the first point. The second point is, all it is if they decide to go that way, they come to us first to make the proposal. But obviously, if somebody else makes a higher stalking horse bid after considering breakup fees and all that stuff, they should go with them. No limitation on fiduciary duty. And on the third point, I think we were agreed on all that. So that's all. Thank you.
Thank you, Mr. Glardy. Mr. Martin, good morning.
Good morning, Your Honor. Thank you very much. I'll address the DIP resolution that was reached with the committee last evening, and will be, I think the language is 99% there, and it'll be embodied in an order that Your Honor will see shortly. Your Honor, I'm not a fan of the worked tirelessly phraseology. I think it's tirelessly overused, but it does apply here. And I'll just mention 6 items that comprise the result of the negotiations last night. Number 1, secured lender objections or informal objections that were present to the retention of SSG as investment banker in terms of the carve-out and use of cash collateral. And these were not before Your Honor, but these were discussions outside of the court. But that impediment to retaining SSG has been withdrawn, and the debtors will move to retain SSG immediately, which the committee is optimistic will result in significant work on a planned funding and or sale to have a restructuring here. Number 2, the BACS language will be and has been inserted into the final DIP order in order to preserve the ability to bring claims on behalf of the committee. or other potential assignee, and to the extent a standing motion is filed to bring such claims, there will be a tolling of the challenge period until Your Honor has the opportunity to consider that standing motion. Number 3, the percentage of revenues that the debtor is receiving from the sale of what's known as memo goods under the consignment agreement is being increased by a point from 6.5% to 7.5%. And I'll note that in the 13-week budget, there's $52 million of that type of inventory, and so a point could be significant. Number 4, there will be a lien on avoidance actions in favor of the secured lenders, avoidance action, commercial tort claims, and the like. But the secured lenders have agreed to the marshaling concept, where they would only look to those assets last after exhausting remedies under all other avenues of collection. Number 5, the carve-out for the professionals of the committee will be increased from $456,000, which it was in the budget, to $750,000, which we think more aligns with the percentages vis-a-vis the debtor's fees that are typically approved in these cases. And the investigation budget of the secured creditor liens, which was limited to $30,000, is being increased to $50,000. Finally, the early termination fee of $1.67 million that was charged a day or two before the petition will be reduced by 25% under the following circumstance. Obviously the result of bargaining and the various leverage, but in the event that the committee does not bring a challenge action against the secured creditor liens within a specified time frame, we'll get essentially a 420 some odd thousand reduction of that, and that money will be that actually piece of the lien will be assigned to unsecured creditors. We didn't say general unsecured creditors to avoid any types of issues with the United States trustee or otherwise under JEVIC. Could be priority, admin, et cetera, but will be taken from the secured creditors lien and geared towards unsecured creditors. So that is the resolution that we reached. We had hoped to resolve a couple of other items, one of which was getting some administrative claims out of the way, like stub rent, which has been an issue. Obviously, unsecureds want to see those claims that come ahead of us out of the way. We were not successful on that, and some other issues, and the secured lenders were not successful on certain other issues as well. But this is the settlement that we reached. I know there are a couple of landlords in court that want to speak to Your Honor and will be objecting with respect to the lack of budget for stub rent. And that's where we are.
Thank you, Mr. Martin.
Good morning, Your Honor. Brian Greer of Greenberg Traurig for Kletz, the tip agent.
Good morning.
Good morning. I'd just like to thank the committee and the other lenders working with us tirelessly yesterday. It was a long day, and all the parties, I think, are happy with the resolution that was reached under the tip order. I just want to point out one other point for clarification with respect to the carve-out. That is being funded by a professional fee escrow account. So just for the avoidance of doubt and for clarity, professional fees that we have consented to will be paid out of the professional fee escrow in the first instance. So there won't be a double dip where there's a carve-out on top of the professional fee escrow. And then I can wait and respond to the landlords if that makes sense.
Sure. Thank you, Mr. Greer. Mr. Fox, good morning.
Good morning, Your Honor. Stephen Fox, Reamer and Brunstein, on behalf of Pathlight Capital LP, as pre-petition term agent and as part of the debtor in possession facility that's been described today. Pathlight's been an active participant in discussions among the debtors, the committee, and the DIP lenders, Eclipse and Restore, and we are fully supportive of the modifications that have been made to the DIP facility as described today. Thank you.
Thank you, Mr. Fox. Mr. Ghilardi.
Thank you, Your Honor. Just a couple clarifications. One, we agree on SSG. Two, Beck's language, we're going to include it. I have to try to figure out a way to appeal it at some point, but I can't. Three is we do agree, and it's really a consignment issue, that the percentage goes from 6.5 to 7.5, so I thought I would stand up on there. One real clarification, though. The early termination fee, the way in which it's to work is the following. The committee will have 30 days. You earn the fee, but if the committee takes 30 days to investigate the liens and early terminates their right, which is shorter than the investigation period, 60 days from the appointment of the committee, then that fee will go to unsecured creditors. So I don't want it to be confused that they have the full 60 days, and if they just don't bring a challenge, this was an incentive to do the lien review early, get done with it 30 days, and then those funds would be available to the unsecured creditors in order of priority. It's not the full 60 days.
Understood.
Thank you.
Yeah, thank you, Mr. Ghilardi.
Confirm.
Okay, thank you, Mr. Martin.
Your Honor, if I may then, I'm not sure. Counsel, excuse me, did you want to address the court?
Well, let me ask a question before we get to Ms. Heilman. I anticipate that Ms. Heilman is going to want to discuss her objections to the DIP. And before we get there, do you have any further evidence that you want to put on other than that you provided at the first day hearing?
No, Your Honor.
Okay.
Mr. Salkowitz, the president of the company, is in the courtroom, Your Honor. If your court has any questions regarding him or anyone has any questions of him, he's prepared to testify in accordance with the first day affidavit and a supplemental his first affidavit about the need and necessity of the DIP and how important it is to the reorganization. Thank you.
Understood. Thank you. Ms. Heilman, welcome. It's good to see you this morning.
Thank you, Your Honor. It's good to see you as well. I think this is my first appearance before you. Good morning, Your Honor. For the record, Leslie Heilman, Ballard Spar, on behalf of the following landlord creditors for the debtors. Acadia Realty Limited Partnership, AR Global, which is ARG CRH AGMD 001, and ARG TCF LOKY 001. Bricksmore Operating Partnership for 4 additional properties, FR Assembly Square LLC, KRG Colonial LLC, and Soundwater Properties, Inc. Landlords did file an objection to the entry of the final DIP order at docket number 129, and they are the owners of approximately 10 of the debtors' retail locations. Your Honor, there have been other objections raised by landlords today in the courtroom, and I think I've either drawn the short straw or the long straw to go first today, but we did strategize so that we're not repeating arguments for Your Honor. I'll try to be brief. However, Your Honor, I think none of the landlord's objections have been addressed by the committee settlement or the other resolutions and the red lines that are in the order. So as set forth in the objection, Your Honor, landlords have legitimate concerns regarding the administrative solvency of these cases, and more specifically the conceded $4.7 million in administrative stub rent owed to the landlords, which is not provided anywhere in the approved DIP budget, and where, as acknowledged by the debtors, there is insufficient availability under the DIP financing borrowings to pay the stub rent at any time in these cases. In fact, any payment has been relegated to the end of the cases and is wholly contingent upon the debtor's ability to confirm a plan of reorganization and the securing of exit financing to pay the stub rent upon emergence. No plan is even on file yet to pay the stub rent. There's no RSA, nor has there been any indication that the debtors will have funding in place to pay the stub rent. SSG, as you heard today, is just being retained to shop a plan or plan sponsor. Your Honor, indeed, landlords do understand that there will be a marketing process, but notwithstanding, the lenders do seek today a full release under the DIP, as well as a waiver of the estate surcharge rights and benefits under 552B of the Bankruptcy Code, absent any provision to provide for some semblance of debtor's solvency. Landlords do not believe the promise of exit financing constitutes adequate protection or demonstrates sufficient administrative solvency of these estates, and therefore we believe it's improper for the lenders to get a 506C waiver when they have not provided any indicia of administrative solvency. In response to the objections raised by us and other similarly situated landlords, the debtors and the lenders focus primarily on two issues. One, the commonality and customary grant of a 506C surcharge waiver in connection with DIP financing, and an assertion that the landlords either are not entitled to adequate protection or have not identified any particular harm that they will suffer in support of the relief sought. I will address each of these arguments in turn. On the first point, Your Honor, landlords understand and agree that DIP lenders often, if not always, request a waiver of the debtor's surcharge rights under Section 506C in exchange for the financing. But the debtors here ignore the very critical difference between this case and some of the cases cited in those objections where 506C waivers have been approved. Here, the budget, or even the circumstances of the case, entirely fails to demonstrate any funding or availability sufficient to not only pay the approximate $4.7 million of undisputed administrative stub rent claims of the landlords arising from the debtor's actual and necessary use and occupancy of the premises to conduct both ordinary course sales as well as outside the ordinary course sales through the GOB process. But also, we have not had confirmation that all post-petition lease obligations under the leases have been fully budgeted in the case. We have monthly reoccurring obligations that have been budgeted in June and July, but we don't know if those incorporate non-monthly obligations that will arise under the lease as well, such as taxes, year-end adjustments, reconciliations, and the like. So right now we know $4.7 million is not budgeted, but there could be a lot more. And the rent is not insignificant in these cases. The lenders can't rely upon the body of case law approving surcharge waivers as standard and customary in what has otherwise been set up as a liquidating case. And while simultaneously forcing the landlords to bear the direct burden of maintaining the debtor's stores and paying the costs of the restructuring process, namely, the May rent that was not paid has funded the case through May. The DIP facility should provide all costs of liquidating the lender's collateral through their chosen forum, which is Chapter 11, bankruptcy. That brings us to the second point, which is the primary substantive issue that needs to be addressed today, the availability of adequate protection for the landlords and whether such adequate protection has been provided. Delaware has been a long-standing pay-to-play jurisdiction, especially in retail tenant bankruptcy cases, which has been articulated by Judge Walrath in Sports Authority, and in order to enjoy the benefits of remaining in Chapter 11, including either through a 363 sale of our clients' leases or a potential reorganization of the debtor's business around the leases, the debtor must provide for administrative solvency. Our objection proposes a variety of remedies through which adequate protection under 363E can be had. We've proposed a number of those remedies to the debtors and to the lenders, each to no avail. Section 363E states that on request of an entity that has an interest in property used, sold, or leased, or proposed to be used, sold, or leased by the trustee, the court, with or without a hearing, shall prohibit or condition such use to provide adequate protection of an interest. Section 363E provides a basis to grant adequate protection to real property lessors in the form of either budgeting, reserving, escrowing, or a conditional 506C waiver to allow for the administrative rent under the leases. Your Honor, Section 361 also is clear that adequate protection cannot take the form of a claim. As we stand here today, other than the concession by the debtors that the landlords have valid, undisputed administrative claims for the stub rent, there has been no showing by the debtors of a budget that actually provides for the payment of that rent, and there has been no confirmation that there will be a successful reorganization here, let alone any commitment for exit financing as we stand here today. The lenders have also indicated there's no availability or borrowings available for the payment of stub rent. However, a review of the budget does show there is availability in certain weeks. So if there were installments of the stub or some type of reserve or escrow arrangement in place, There is availability, however, it's not in the rent is not in the approved budget, so they can't use that availability to pay the stub rent. As we set forth in our papers, there are a number of ways to provide the adequate protection, and we think the simplest possible way in this case is to budget for the payment, as has been done for all other administrative expenses in these cases, and condition any Section 506C waiver until such time as the stub rent payments are made. If it is true that this case is on a fast track to a reorganization and there will be a confirmed plan that will pay all administrative claims in full, where is the harm or the prejudice to the debtors and or the lenders in budgeting for that stub rent, especially if there's actual availability under the DIP to do so? This solution would not disturb any of the DIP lenders' rights, so it is not a renegotiation of their rights under the DIP credit agreement. The debtors are also conducting certain store closing sales, so the court could direct funds sufficient to pay the stub rent for any of the liquidating stores from sale proceeds of the inventory for payment to those landlords upon rejection of those leases, which has been done in numerous cases, including Brookstone and Destination Maternity. As indicated, yet another option is to just simply condition any 506C waiver made subject to the payment of the stub. So it's solely to the extent of the unpaid stub rent. This was done by Judge Silverstein in JMM Sales. Contrary to the debtor's argument, landlords are not demanding that the stub rent or any post-petition unbudgeted rent be paid immediately. Nor are we suggesting that the lenders can never obtain a 506C waiver in these cases. Instead, what we're suggesting is that at this early stage of the cases, where there's much uncertainty and even the administrative solvency of these cases isn't left in doubt, it's inappropriate to waive the substantive right provided by the Bankruptcy Code for the specific purpose of ensuring administrative solvency of cases. The landlords have provided and continue to provide critical and unquestionable value to these estates, not only through the use and occupancy of the premises, which is undeniable essential to the debtor's operations, but is also a necessary component to any going concern value of the debtors. The cost of that benefit is the freight of these Chapter 11 cases, the rent due under the leases, and it must be provided for. The case law says it should be provided for. It is inappropriate to grant the 506C waiver, which is the only alternative that the debtors will have to pay administrative claims of these cases if it's rendered administratively insolvent in the coming months. For these reasons, landlords respectfully request that the 506C waiver not be granted unless and until the debtors and the lenders demonstrate that they will be able to pay the costs of the cases through an approved budget.
Thank you, Ms. Hyland.
Thank you.
Good afternoon, Your Honor. It's a
Good
pleasure to appear before you for the first time.
Yeah, good to see
Robert Lee Hain, Kelly Dryan Warren, on behalf of landlords Brookfield Properties, Kite Realty Group, Blumenfeld Development Group, and Oak Street Real Estate Capital. Your Honor, for the same reasons articulated in Ms. Heileman's objection, we filed an objection at docket number 141 on behalf of our same landlord clients. There are 4 locations. The total unpaid rent at those locations is approximately $245,000. Your Honor, we don't need to belabor the record, and we certainly appreciate the efforts of committee and the debtor and everyone in resolving their issues. We understand a lot of progress was made, but we would ask, Your Honor, that you join your colleagues on the bench and prevent the debtors from granting that 506C waiver when they haven't provided for stub rent and they haven't provided any adequate protection under 363E for the payment of the stub rent in May. Your Honor, I was able to have some conversations with counsel for the DIP lenders and Hilco. We made some proposals along the lines of what Ms. Heileman suggested, that this stub rent be paid in installments, and as of yet, we have not received any response that was substantive or provided any adequate protection. If Your Honor has any questions, I'm happy to answer them. But again, joining the arguments to Ms. Heileman.
I appreciate that. Thank you.
Thank you very much, Your Honor.
Thank you, Mr. Lee. Mr. Murphy.
Your Honor, a brief reply. We need our landlords to support this reorganization, Your Honor, and it's no secret that without the landlord support in these cases, we're not going to be able to reorganize it. This will be a liquidation. And I really do wish we had the funding available to pay the stub rent. It's not an unreasonable request, but we have what it is apparent, Your Honor. What is in the budget, Your Honor, that's been attached to the DIP order is the payment of $5,521,000 this week, or this coming week. So that's for the June rent. And there's another $5,175,000 for the payment of July rent. And the budget only goes through, Your Honor, the end of July. And certainly we would object if we are proceeding towards a reorganization, August rent will be paid. Unfortunately, Your Honor, we also have, as a principal expenditures, approximately a payroll of, it varies obviously, but at some points it's almost over $3 million of payroll. And when you look at the budget and the availability is thin, Your Honor, and certainly insufficient to cover the fluctuations in the availability, because when we have to pay rent or we have a big payroll week, we can't be running a business that has these types of expenditures without some modest amount of excess availability. And when you look at the budget, we're running excess availability of less than, for the week ending, the $700,000, $1 million. So there's very less availability, Your Honor, in some weeks that we can't afford to pay any stub rent. And I've unfortunately spoken to many counsel and said, you know, we'd love to do it, but we can't. And that's the reality of the situation. We are filing a plan of reorganization and disclosure statement this coming Friday, Your Honor, less than 30 days in the case. And front and center in that plan will be a commitment that stub rent will be paid as an administrative expense on emergence. Now, I can't guarantee that, Your Honor, that plan is going to be confirmed, but this is not a case where we're asking landlords to wait for an indefinite period of time. As we say, we're less than 30 days in the case, and we hope to get confirmed by the end of August, Your Honor. Effective date, confirmation date mid-August, with an effective date the end of August. And so this is not a long period to wait. Is there uncertainty, Your Honor? There is. There is certainty, though, however, if we are required to pay rent of $4.7 million, or even some of that on some schedule, that there will not be a reorganization, that this will be a liquidation. And it is certain that there's going to be at least 70 stores. We've already closed 10. We hope to limit it at 10. But we will have to close these stores, and this will be a GOP. And our sentiment of talking with many landlords, and Mr. Salkowitz will be here to say, is these landlords would like to see Christmas tree shops survive. They, of course, want to get paid their rent. But I don't think it's in anyone's interest to basically foreclose any opportunity for a reorganization by requiring the payment of stub rent. So, Your Honor, I respectfully suggest that under the circumstances where the bankruptcy code does not require when stub rent has to be paid, that we proceed forward and try to get a case confirmed and address the stub rent at that time, and as well as adequate assurance. Because on top of the stub rent, there's another $6 million owed in back rent. And those amounts will never be paid if this case is liquidated, Your Honor. So I think everyone has a lot to lose if this case is not reorganized, and we're hopeful that the landlords will support us. We're pleased that the dispute regarding the ability to pay and retain an investment banker to assist the company in securing the capital necessary to confirm a plan. There's a lot of people who express interest in it, but we have to take that interest and convert it into a funding commitment and get this plan confirmed, Your Honor. And we're hopeful that can be done, but I think we deserve the opportunity, and I think the landlords and the vendors and all the other people, and they have 3,000 odd employees that work for this company, deserve that opportunity. So we would hope that the court would approve it, the waiver and the DIP motion, because without that, it's game over. Thank you, Your Honor.
Well, Mr. Murphy, the landlords make the point, and I think it was Mr. Lehane who said that I would only be joining my colleagues if I said that if you're not paying for stub rent, that you don't get the 506C waiver. How is he wrong about that?
Your Honor, I can't speak to that practice as every case is different, Your Honor, factually. And it's
Well,
not-
are you aware of cases in this district where stub rent was not provided for and over the objection of the landlords, the 506C waiver was nonetheless granted?
We could not find any reported decisions to that effect, Your Honor.
Yeah. I mean, that's my problem with this. If I understand that you don't have it in the budget to pay stub rent, but the 506C waiver, that's kind of the backstop for landlords. Mr. Ghilardi would like to be heard, so
Thank you, Your Honor.
hear from him.
Your Honor, I haven't gone back to every one of my own opinion, my own cases, but Judge Sanchi in Goodies, which is where this issue came up, did in fact give a 506C waiver, and then with respect to the landlords, and this came back from Judge Walrath at that point, and I don't want to talk about the code and what the code actually says, said that stub rent is an administrative claim, 503B, that doesn't have to be paid to the end of the case. The landlord, and the code says this as well, gets the monthly rents according to the code, which Congress said you get monthly rents, but stub rents you don't get. So, and then third, let's go to 506C. 506C is the debtor's business judgment under the Supreme Court case in Henhouse. You've heard back and forth that the debtor has agreed to it. No other party has standing to challenge or surcharge anybody. It's the debtors. And what you've heard, and no one challenged the testimony on the declarations, that the debtors made a business judgment to give the 506C waiver. So you would have to rule that that business judgment, all the gives and gets, has been violated, that somehow they didn't exercise their business judgment. This is just one aspect of business judgment. It is unfortunate that there is not money. Mr. Lehane said, and others have said that this is now what's happened. But I'm not sure I've seen cases, maybe some judges do put 506C as the quid pro quo, but they have to challenge the business judgment of the debtor for why they got this, why they did this, what they got. The committee is supportive of the 506C waiver, despite the fact that 2 members are on the committee. The 506C is a business judgment decision. No one's challenged the business judgment. They do get certain payments. I understand the landlord's position. That's one of the reasons why we think adequate protection doesn't have to come in money. It doesn't have to come in the 506C. We're hiring SSG to do a sale process, to do a plan of reorganization. They're free to come in and make a request if this case is not going where they think they're going to get it. But it's not a requirement that put in the DIP budget, and it's not a requirement of the business judgment that the debtor has to satisfy the business judgment by always putting in stub rent, even in these circumstances. So I think we can go statutorily on 3 points. 1, 506C is the debtor's business judgment. No one has challenged it. 2, the landlord's protection is in the code. It's 365D4. They can be paid on a go-forward basis. 3, stub rent is a 503B under Delaware law. You don't have to pay that. That just leapfrogs. And whether it's immediate payment or over time doesn't mean that it can't come up during the course of the case if they don't like where the process is going. But Mr. Murphy said that you're going to get a plan on file, you're getting SSG on file, you're running a sale process. Those are forms of adequate protection for the committee. And if they don't like those forms, they can come back and file a motion for adequate protection. But it doesn't mean it has to come in the DIP now. You can have them come on a motion. And this code provision, 363E, says on request. And it's on request for them to ask for adequate protection, not necessarily as an objection to a DIP or a 506C, because they don't really challenge the business judgment on 506C. So we would ask you to deny that. Without prejudice, they're coming back. But I don't see how, without raising questions of the business judgment on the gives and takes on that budget, the gives and takes with the committee, that they've actually challenged the business judgment of the debtors to give the 506C waiver.
Thank you, Mr. Clark.
Thank you.
Let me hear from Mr. Greer first.
Thank you, Your Honor. Brian Greer, Greenberg Shroud for Eclipse. I agree with everything Mr. Ghilardi has just said, and I just wanted to add one other point. You know, Judge Silverstein at Central Grocers, in the context of 503B9 claims, you know, remarked that the DIP lenders are not guarantors of the debtor's bankruptcy. You know, we are here to support the debtor. Your Honor heard on the first day of the case It's a tight case. Mr. Murphy said that today, but we're here supporting the debtor to get to the right place, but we should not be the guarantors of this Chapter 11. In addition to that, if we are at a place where 503B claims just show up and get added to the budget because they're here, this is not going to be the end of the 503B claims that show up at first day hearings or second day hearings to be included in the budget and to be paid. They have rights under the bankruptcy code, which is to file their motion for payment of an administrative expense, and it can be addressed at that time.
Okay. Thank you, Mr. Greer. Mr. Lehan.
Your Honor, just a quick response to Mr. Ghilardi and a couple other points. With respect to adequate protection and 503B claims, Section 361(3) makes it absolutely clear that an administrative claim is not adequate protection. It can be almost anything else. And also with respect to the Goodies decision, Your Honor, Mr. Ghilardi and I are well aware of that one. It was an issue about 365D3 and 503, not 363E. So it is a separate issue, Your Honor. And I think it's worth remembering that what we're talking about here is a process where the debtor's lenders have collateral that is being sold, liquidated, and stored in landlord's premises, in the landlord's property. It's separate from vendor claims. Use and occupancy is a very distinct type of use, and it's absolutely entitled to adequate protection. There's a long line of cases that says that we've cited in our briefs. So, Your Honor, agreeing with Ms. Heilman, I had one other point that was with respect to, give me a moment. Well, with respect to when the process was set up and what you understand is going on here, Your Honor, and we understand landlords want to be cooperative with the debtor, right? Obviously, we want to see a going concern. And the process for including some adequate protection, but putting the stub rent in installment payments throughout the course of the 13-week budget is one that has multiple benefits. We understand that the debtor may be coming to the landlords and looking for rent concessions, and it may be looking for waivers. And I'll admit we may have been aggressive in our objection asking for payment now, but we understand payment now isn't what we're really looking for. We're looking for some assurance of payment. The risk of administrative insolvency shouldn't be entirely on the landlords. And by putting this out in installment payments in various portions of the budget, some portion over monthly payments and perhaps some portion at the end of the case, gives the debtor the optionality to negotiate with the landlords about what an appropriate go-forward footprint looks like. And it's been a very successful outcome in numerous cases. And then with respect to the Delaware cases, there's certainly, whether it was 24-Hour Fitness, Radio Shack, or various other cases since Goodies, numerous of your colleagues have all said the 506C waiver is not appropriate unless there is some adequate protection put into the process, into the budget or otherwise, that will guarantee some form of payment. Strike that. I agree with Mr. Greer. The DIP lender's not a guarantor here, right? But we'll give landlords some assurance, some adequate protection for the payment of that. Thank you very much, Your Honor.
Mr. Lehan, could you please address Mr. Ghilardi's argument that this is really an attack on the debtor's business judgment in granting the 506C waiver?
Well, I would say, Your Honor, again, the way the process unfolds, right? You have a debtor that needs to borrow money and it needs to sell inventory. So they get together with the lenders and they get together with Restore and they come up with a mechanism for trying to make the best way through a Chapter 11 process. That's the same way this unfolds in various cases. And the debtor is really at the mercy of what the lenders are demanding from them. And we have yet to see a debtor say, yeah, we will refuse to give you the 506C waiver. What typically happens is we have a judge who says it's not appropriate to give the 506C waiver completely unless there is some adequate protection given for the payment of the stub rent. So we understand that it's an issue of the debtor's business judgment, but that business judgment also is in the shadow of what the court's decisions and what this court's decisions are with what administrative expenses the debtor should have to pay and the lender should have to fund and Restore should have to fund in connection with a process that the lenders and Restore will all be making money through a process that uses the landlord's premises. Thank you very much, Your Honor.
Thank you. Ms. Heilman.
Good morning, Your Honor. Leslie Heilman, Ballard Spar, again for the record. Your Honor, just briefly, just to address some of the points Mr. Lehane just raised, as well as your question with respect to the business judgment standard. Your Honor, we recognize that it is a surcharge right of the debtors. It is not ideal to limit a 506C waiver to the extent of the stub rent, because it's really the debtor then has to retain that surcharge right and whether or not that brings. But it does provide some adequate protection here, Your Honor, especially because we have not shown administrative solvency. I don't believe I think the record is very clear that there is an insolvency here at least to the tune of $5 million. Your Honor, and we don't have to guarantee administrative solvency, but there is a very big difference, Your Honor, between 503B9 claims and 503B2 claims. And, Your Honor, we're talking about actual use and occupancy of premises during the post-petition period that is not being paid. And there's no mechanism for that payment except with exit financing that is not secured today. So, Your Honor, I do recognize, I think the landlords support the debtor here. They would like to see a reorganization here. But what the 506C waiver gives for adequate protection gives the state a mechanism to make up for if there is an administrative insolvent estate. We stand here today, we don't know what's going to happen, but it's been very, very clear, as some of your colleagues have indicated, is there needs to be some mechanism in place to provide for the administrative solvency of the cases, especially in retail cases, and that's where the adequate protection comes in. Either a limited 506C waiver, an escrowing, a budget, a reserve from sale proceeds, and Your Honor, it comes down to the risk is solely on the landlord creditors in this case, who are valid administrative creditors of these estates, and Your Honor, it shouldn't go entirely on them. The budget provides for every other administrative expense in this case is to be paid during the term of the case. The only, to my knowledge, that is not budgeted is this administrative stub rent, which is for actual use and occupancy. It is not a 503B9 claim. The cases that have been cited were not retail cases with the exception of True Religion or Central Grocers, and both of those decisions were with respect to 503B9 claims, not 503B2 claims. Thank you, Your Honor.
Thank you. Mr. Rosner, would you like to be heard?
Yes, Your Honor, and our co-counsel, Ms. Biferato, is also on the line as well. Thank you. I would just like to add a couple of things. One is I disagree with the notion that 506C waiver is exclusively within the debtor's reasonable business judgment. It is a statutory right and protection of the entire estate, and it's a statutory right that a trustee has if this case were converted or if a Chapter 11 trustee were appointed. And the parties are asking the court to waive that statutory right. I think that falls outside of what it would be ordinarily in contact with reasonable business judgment as far as what the interest rate is going to be, what the milestones are going to be, or if the debtor is going to waive particular causes of action, but there's always a quid pro quo for that too. And that is that the committee is given an opportunity to investigate those same causes of action. So nothing is actually waived merely because of the debtor's reasonable business judgment. In addition, there was a comment about the lenders are not the guarantors of the Chapter 11 case, and I don't disagree with that at all. I also don't disagree with the notion that a court cannot compel a lender to loan the money to the debtor or to loan money for particular things. But a debtor is also not entitled to a lender is also not entitled to a 506C waiver. And this idea that it's being almost taken for granted, is somewhat offensive. And that the quid pro quo for the 506C waiver in this district and many other districts is that the budget cover at least known and reasonably foreseeable expenses, administrative expenses of the estate during the time period in question. And it's a known expense. It was known going into the case. It's not a surprise. They knew the case was intentionally filed after the first of the month in order to take advantage of this district's precedent. And it should have been reasonably foreseeable and known that there's going to be an administrative expense for May rent. And so that should be budgeted. And as the other counsel for the landlord has already argued, the landlords aren't asking for immediate payment. And just like professional fees or other administrative expenses, it can be covered in carve-outs and escrows and reserves and things like that. And so I don't think what the landlords are requesting, the relief we're requesting, I don't think is unusual. It's standard practice, and it's a risk-shifting exercise. And this court should not shift the entire risk onto the landlord body. The court should shift the risk onto the party that's going to benefit the most, no matter what direction this case goes in. Thank you.
Thank you, Mr. Rosner. Is there anybody else who would like to be heard? Okay, I hear no response. I'm not going to require that stub rent be paid under this budget. However, as is, I believe to be the universal rule in this district, I'm not going to permit a 506C waiver when there's no provision in the budget for payment of stub rent. So that's my ruling on the DIP. And in other respects, I understand that it's uncontested, and I would approve it. We'll need to take a lunch break. I have a meeting in the next 15 or 20 minutes at most. So I would understand if the debtors and the DIP lenders want to have a discussion while we're on our break.
Your Honor, Ms. Meltzer said, would you like to address the other motions, Your Honor, or should we deal with the
No, let's keep going.
Okay. Let me turn it to Ms. McLaughlin-Smith. She's took front and center on the store closing motion, Your Honor.
Good morning, Your Honor. Marcy McLaughlin-Smith of Troutman Pepper, proposed co-counsel to the debtors. As you heard earlier today, we are fully consensual on the revised final store closing order. Before I see how Your Honor would like to proceed as far as a walkthrough, there was one question that Your Honor had asked at the first day hearing with respect to fast pay laws, so I just wanted to provide you an answer with respect to that. For the current sales that are being run, they're out of 7 different states. Florida and Georgia do not have any law with respect to when a terminated employee has to be paid, so those are not relevant for this provision. Massachusetts and Michigan. Massachusetts requires immediate payment of a terminated employee's final wages, and Michigan requires payment as soon as the final wages earned can be calculated. And then the remaining 3 states are New York, Pennsylvania, and Virginia. Final wages to terminated employees are due on the next scheduled pay date. Although, of course, that could end up being condensed if employees are terminated, for instance, on June 29th, and then June 30th is a payday. There's that 1 day difference there, but there'll also be an additional calculation that will have to go into the final wages because they won't have worked that final day of a traditional pay period. And so, Your Honor, I don't have the exact citation of the paragraph in the order, but we do request relief from the 4 corners of those fast pay laws in terms of timing of payment to terminated employees. But the order does provide, and the debtors will make every effort to get those final paychecks to terminated employees as soon as possible.
Okay, I appreciate that's very helpful to me.
And so, Your Honor, as a housekeeping matter, we did receive informal comments from the U.S. trustee, certain landlords, the National Association of Attorneys General, Eclipse, and then the committee obviously had their objection filed. I have 2 forms of red line for Your Honor. One is a cumulative against the as-filed final order, and one is simply an incremental red line against docket 161 that was filed yesterday and submitted with the agenda and hearing binders. So I'm happy to provide whichever red line Your Honor would like to walk through.
Could you hand them both up, please?
Yeah.
Thank you.
May I approach?
Yes, please do. Okay. Thank you. So the only revisions from what you filed yesterday are to paragraph 12.
That's correct, Your Honor, to reflect the increase of 6.5% on augment to 7.5%.
Okay. Do you have anything else on this motion?
I don't, Your Honor. I'm happy to answer any questions that you have.
Okay. Does anybody else wish to be heard on the motion to approve the assumption of the store closing agreement? Okay. I hear no response. I'm happy to approve that motion as revised. Just ask you to upload the newly revised order under certification of counsel, and we'll enter that order.
Thank you, Your Honor. We will do that.
Thank you.
Your Honor, I believe there are two other motions I'd like to address would be the consignment motion, Your Honor. And I have, as Ms. Smith did the last time, a proposed order to reflect the changes that was made to the order that was attached to the original motion, Your Honor. And the major change on that order that was attached to the original motion on consignment relates to the change in fee referenced by the committee in connection with the sale of consigned goods in the event of a liquidation, increasing the debtor's shares from what is originally, I believe, 6.5% to 7.5%. That's in paragraph 8. In paragraph 9, there's a provision that the committee will receive the same reports regarding the consignment sales as the currently provided to the DIP lenders, Your Honor, in the consignor. Unless Your Honor has any questions, I think we're set on that order.
Now, I have had an opportunity while I'm sitting here to review the revisions. Is there anybody else who'd like to be heard on the motion to assume the consignment agreement? Okay, I hear no response. I'm prepared to enter the order as revised, and again would ask that the revised order be submitted under certification of counsel, and we'll enter the order.
Thank you, Your Honor. And just the last housekeeping, we haven't been able to keep track with the court's docket. Just was checking on the wage motion, which I believe is agenda item number 6 on today's agenda. I'm not sure the court had any questions about that or whether that order is going to be entered, Your Honor. An order has been submitted by certification of counsel. I believe Mr. Meltzer's office did that earlier. But if you have any questions up here.
Yeah, I do have a question. On paragraph 6 of the revised order, you've struck all the language regarding the authority of employees have really from the automatic state to pursue their workers' comp claims. I'd like to understand why that's been struck.
Only because, and the U.S. trustee made the same question, Your Honor. We received a comment, and I forget from whom, that particular relief was not requested in the motion itself, but I've informed the U.S. trustee that the debtors take the position that no relief from stay is required for an employee to pursue its rights for workers' comp claim, and that's and I'm prepared to live on that. The debtors are prepared to live with that statement on the record, Your Honor. We just didn't see the comment that we received. And I forget from whom was saying we didn't see that particular relief requested in the motion, Your Honor.
Okay. Well, it was contained in the interim order.
It was.
And as you're explaining it, it sounds like you think that original provision was really more in the nature of a comfort provision.
I believe that's the case, Your Honor.
If the party that asked that it be struck is in the courtroom or on Zoom and would like to be heard, I'd like to hear from them. Okay, they're not here. I hear no response. I'm not prepared to strike that provision. I think that what striking it would do would be to create a great deal of confusion. It would give the impression that while on an interim basis the stay was modified to the extent necessary to allow workers to go and pursue their workers' comp claims, it would certainly lead to the impression that the court is now finding that there is no such stay relief. So I'm not prepared to enter the order with that language being struck. So if you'd like to restore it and submit an order under certification of counsel, I'll be happy to enter it right away.
Be happy to do so, Your Honor.
Okay, thank you.
Thank you, Your Honor.
Is there anything else on the agenda, Mr. Murphy?
I'm sorry, Your Honor. Just the main course, Your Honor, the dip order.
Yeah. Well, like I said, I suspect that you want to talk to your lenders, given my ruling. If you'd like to come back at 1:30 and tell me where you are, that would be fine. If you, on the other hand, find that 1:30 does not give you enough time, we can either deal with the order under certification of counsel, or we can get back on Zoom if there are other issues that you want to either ask me to resolve or that you'd like to let the court know about.
Your Honor, I'm inclined to come back and report to you at 1:30 where we're at, if that's acceptable to the court.
That is fine. Okay. Anything else?
That's it, Your Honor.
Okay. We are in recess until 1:30.
Recording stopped.
Please be seated. Good afternoon.
Good afternoon, Your Honor. If I may, Harry Murphy. I think Mr. Galati would like to address the court, Your Honor.
Very good.
I don't know, Your Honor, it's probably, I think we've resolved it with the landlords and the 506C. I think it's easier, I don't know if Your Honor has a copy of docket number 82-2. I have it as page 6-7, which is really the DIP budget. It's probably easier to address and see it visually that way, how we've sort of come about a resolution. We might be able to hand up the budget if it's easier.
I don't have a, I'll see if we have a clean one, Your Honor. I should have a clean one for the court, Your Honor.
Okay.
It's Exhibit B to the order, I guess?
There you go.
Thank you. May I approach, Your Honor?
Please approach. Thank you.
I'll give you the
Okay, great. Thank you.
Now I've got to get back to the page. Your Honor, it is it's page 6 of 7, which, if you're following along, you'll see it's actually just a column across, and it has the revolver borrowing base schedule. There's a line that says less availability covenant, and then there's an excess availability covenant.
Yes.
And this budget needs to be amended anyway. So first, it will have to be amended to add up on a proportional, on the weeks, the 750, the increase in, I think it's $294 million, $100,000, $294,000 will be added to that on a proportional basis for the committee's fee. So that,
Okay.
the 61 is going to be too high already.
Okay.
And then obviously there's an upside at some point if the committee resolves its investigation by June there'll be an increase in availability as per the other conversation. But I think it's easy just to use this budget. What we've agreed with the landlords, which will resolve their objection to the 506C issue, is the following. We will start as of the week of the 3rd of June, which is this week, setting aside, we're talking about whether it's cash to the debtor or it's going to be a line that we reserve it, $50,000 the weeks of, at least $50,000 a week for, it's $50,000 a week for the week of June 3rd, June 10th, June 17th, June 24th, July 1st, July 8th. That's $50,000 that'll be dedicated to stub rent, call it a stub rent reserve.
Okay.
The week of July 5th, actually, that July 15th is 50. The week ending July 22nd will be $1 million.
Okay.
I hear no? No, I think he just asked for the 3rd week, July. Let me double check. Oh, okay. I'm sorry. I am corrected. It is the week of July 15th that it gets funded $1 million. And then the pattern will be 50 after that on July 22nd, 50 July 29th. We're going to do a revised budget and it'll go out, but the pattern will be the same. You'll pay the rent the week ending the first week in the month. The second week after the week ending, they pay the rent. They're going to pay the $1 million. Critically, it's not on this chart, but assume that we had one more week, which is the week, 30 days, September, April, June, and November. So it's the week ending August 5th. They're going to pay the rent. But that reserve is going to be added pro rata to the rent. So by that time, I think our rough calculation was about $1.3 or $1.4 million. So almost a quarter of the stub rent will be paid pro rata out to the landlords getting rent in August. As you will see, so the availability will be decreased, but we've now put a line item in for the stub rent. And so everyone is clear, we're not, because the first 2 weeks are very thin, we've agreed, the lenders have agreed that there won't be a covenant breach if they don't get below, if they fall below that minimum liquidity number.
Okay.
So, but again, and I'm going to be clear with the court, that is in exchange for a 506C waiver. And that if there is defaults, that's not a guarantee that these rent payments are going to be made. As we talked about, if there's a default, we call it default, there's a DIP default, we may have to be back at the table with the landlords, but we will have gotten, again, those 2 weeks, a final 506C waiver, if Your Honor is agreeable, that we will have a 506C waiver now for extending that and putting in these line items.
Good. Would any of the landlords like to be heard?
Good afternoon, Your Honor. For the record, Leslie Heilman from Ballard Spahr again. Your Honor, we have, Mr. Ghilardi has, I think, accurately reflected the negotiations that we've had during the break. We thank you very much for the time. Your Honor, I think based on the availability of the debtor and as well as the rent is going to be reserved for the benefit of the landlords and then paid out as it accrues. Once it hits $1 million, it will be paid out with the monthly rent. I think it provides sufficient adequate protection at least up through about half of the stub rent by the time they potentially could emerge from bankruptcy, and then the remaining would be paid out at emergence. And it at least provides that you know, the landlords have some skin in the game and we can, you know, be made whole to the extent of the unpaid stub rent. I think that it balances the interests and we would be acceptable to this arrangement.
Okay, thank you, Ms. Heilman.
Thank you.
Anybody else in the courtroom before I get to Mr. Rosner? Okay, Mr. Rosner?
Yes, Your Honor. Thank you, Douglas Rosner, for two of the landlords. I agree with Ms. Heilman. It's not ideal, but it's I think it's a good compromise, reflects the cash constraints that the debtor's facing, and gives us some protections going into this Chapter 11. And that's really what we were looking for, is some fairness and balancing of risks. And I think this does that.
Very good. Would anybody else like to be heard on the dip? Mr. Murphy, would you like to be heard?
Just wanted to make on the record, Your Honor, I think we talked with counsel. We have a couple of things to do. We have to do a budget that reflects the change for the committee's compensation. This fund that we're creating for the benefit of the stub rent, and we have to get a agreed order cleared with counsel and submitted to the court. There's a milestone. We intend to do that forthwith. There is a milestone on the present dip that we have this dip order entered by Friday, and but Mr. Galati can correct me if it's in process. So we're making progress on that. He's not going to hold us, the debtor, to that particular milestone, so that we're not all working in vain here.
Okay. Okay. Well, based upon the comments of counsel, I do find that the objections of the landlords on the 506C waiver issue have been addressed, and I'm prepared to enter the dip order, including the 506C waiver that was requested.
Thank you, Your Honor.
Okay. Is there anything else for today?
I don't believe so, Your Honor.
Okay. Then we are adjourned.